Welcome on behalf of the Direct Tax Committee. A very warm welcome to all the participants here. We have an esteemed panel. We also have KR Shekhar here with us, who is the Senior Vice President of the Chamber. I will request Shekhar to start off with a brief theme setting for this panel discussion. And then we will request our guest speakers for the day to give their insights, their opening remarks for 5-6 minutes each, and then we'll start off with the panel discussion. Once again, very warm welcome to you. I hope you will enjoy the session. Over to you, Shekhar, for the theme setting.
Morning, Bala. Thank you so much for organizing this to you and Sunil. Morning, Padam, PVS, and Mr. Ashutosh Dixit. Welcome to the BCIC webinar today. The theme, Bala and Sunil has done a good job of organizing a seminar on the most topical subject, honoring the honest taxpayers. This is one of the themes of the government of rewarding the honest taxpayers and also introducing the faceless assessment and the appeals. Actually, Padam and me discuss whether it is a faceless assessment or farce. That's something only we know by when we go through it, we know it is a faceless or farce. But putting that aside, if you go back the Tax Administrative Reform Commission chaired by Dr. Shom, where the committee made a detailed recommendation of e-assessments using technology to bridge the gap. And also in that one of the most important recommendations made by that committee is that the assessing officer who passed the order should not be responsible for collection or revenue targets. The assessing officer who is passing the order should not have any revenue targets, then only he will be passing a unbiased and a fair order. And the tax collection, because I was part of the committee with Mr. Sanjay Kumar and a couple of other professionals, the committee recommended that the collection target should be given to a person who is not part of the assessment itself. It should be an independent person. And the committee also made a recommendation of not a jurisdictional-based assessment, but an industry-based assessment, so that the assessing officer who does the assessment gets the required expertise and doing the assessment. And very often we see in the department, particularly it's so more relevant in the recent context on transfer pricing and international tax, because the officer needs to know the industry, needs to know the organization, needs to know the business in which the industry operates. And the officer, by the time he knows complete 2 years or 3 years, he gets transferred. And then he goes to a completely new department. In fact, I know very well one of the very intelligent officer in Bangalore was the international tax officer. I don't want to name him. Of course, if I say the person, if I say the background, people will know. He was one of the earliest guys in Bangalore international tax. When Bangalore set up the international tax, he was the earliest guy. He was an additional commissioner. Very smart chap, very knowledgeable. Probably all the software now, whether it is subject to tax, the matter in Supreme Court, I should give it to him because he only raised the issue in those days, much before anybody. Whether it is right or wrong, it's a matter of debate. But at least he had that knowledge, he had that experience, he had that interest in doing the subject. But what I understand is that he went to Vienna to study the international tax. He did that. Later on, he was doing some appeals at leather industry and processing industry, which is absolutely unconnected to the subject he was doing it. So, this is due to this reason, many reasons, Shom Committee, Tax and Reform Commission recommended that the industry-based assessment should be there. People should have experience in the industry. And then we should use technology more, and that is what the concept of e-assessment was brought in. Now, the government introduced the e-assessment with the belief that there will be minimal interaction between the taxpayer and the tax officer. While it is good that there will be minimal human interface and human interaction between the taxpayer and the tax officer, but whether it's going to create a complete change in the way the assessments are going to happen is a matter of debate in my view. Because unless the assessment moves to the industry-based assessment and not a jurisdiction-based assessment, then only the assessments will improve. Quality of the assessments will improve. Second, the fundamental problem with the tax assessment is that the assessing officer has got a revenue target. So at the end of the year, he is going to make the artificial disturbances in order to meet the revenue. To what extent the e-assessment is going to help, I do not know. E-appeals, a very good concept, e-appeals, by which again you are minimizing the time, all the stuff, human interaction, problem, minimizing the perceived corruption, all those things are positive. Again, the challenge on the appeals is that a CAT appeal should be given allowed to pass an order which is a fair order. Last year there was an instruction to the CAT appeals from the CBDT. Year before last year, just 1.5 years back, where they said all the major demands, wherever there is a demand is exceeding X amount. No, it was not a written instruction, a verbal instruction, because a CBDT member came to Bangalore and Chennai and a couple of places. He reviewed all the orders, all the appeals. He said that more than certain demand, you please pass the order against the taxpayer, let the tribunal decide it. I have a very interesting case where on the same issue, 2 years appellate authority passed a favorable order. On the same issue, the same appellate authority passed an order against me. When I asked him, Shekhar, this is my problem, I can't help it, you will win in the tribunal. So a mere e-appeal will not help unless the CAT appeals are allowed independence, are allowed free, and they are given freedom to pass a fair and transparent order. Padam can recollect and PVS can recollect. When we had appeared before officers like Dr. Lakshmikant Rao and various senior officers, those CAT appeals those days exercise absolute fair and transparency. They're just fair. They never bothered it is revenue or whether it is taxpayer. They looked at the CAT appeal, they looked at it as an independent judicial member and passed the orders. Be it Dr. Lakshmikant Rao, be it TNT Nair, be it T.S. Krishnamurthy, who became Chief Election Commissioner. Gone are the days. I do not know how many CAT appeals today's days are going to be like those stalwarts who pass the order in a fair and transparent manner. Whether merely an e-appeal will help to transform the system, I do not know. Yes, it minimizes the interaction, but what is required is a fair and transparency in the tax administration. The last point, honoring the honest taxpayer. Very good title, honoring the honest taxpayers. But what is a honor for the taxpayers, I do not know. Whether merely because disincentivizing the dishonest payer is an honor to the honest taxpayer, I do not know. But theme is good. There is a lot of what I would call gap between the intention and the action. Well, the intent is good. To what extent it will get implemented at the field level is a matter of a debate. I saw one WhatsApp circulation was going on. CBDT chairman is asking Sadhguru as to what the department should do to inspire the confidence among the taxpayers. While I appreciate that he has gone to Sadhguru for getting a spiritual knowledge, but instead of going to Sadhguru, if he listens to the tax words of some of the tax corporate administrative taxpayers and the tax assessees and bring a action point to implement it, he doesn't have to go to Sadhguru. He can go and tell Sadhguru, this is what I heard and this is what I can bring a piece to the country, to the taxpayers. Second, what the government should do is that instead of looking at it, who was appointed, show him what is the reason, the entire Tax Administrative Reform Commission report of Shom Committee has to be completely implemented. I read in the website how the report has been implemented. It's a completely farce, in my view, the implementation of the Tax Administrative Reform Commission report. Completely farce, in my view. Not even a single recommendation of the TARC has been implemented in letter and spirit. Some points here and there has been taken and implemented, like this e-assessment and e-appeal. Is this a right implementation? I have my own doubts, but I don't want to steal the thunder from Padam, PVS, and Ashutosh Dikshit. Ashutosh Dikshit has got experience of both a seasoned administrator and is also a part of the direct tax code. When the direct tax code was not the first time direct tax code was found, subsequently direct tax code was reframed. Ashutosh Dikshit was part of the group. I had the benefit of interacting with him as part of the seminar in Bombay, where Roy Rothkin Chamber at the point. And then later on, I'm Ashutosh Dikshit is my colleague. I'm proud to be working with Ashutosh because he's got a wealth of knowledge and experience in the subject on administration as well as on the other side. Padam Khincha, nobody needs to introduce Padam to the Bangalore crowd. He is very well known and respected and is known for his forthright views. Again, PVS, my very good friend. industry, practice, wealth of experience. I don't have to introduce PVS also to the Bangalore crowd. And Bala and Sunil has got a tremendous job of getting 3 panelists. And with Bala's knowledge and Sunil's experience, I'm sure you will enjoy this session today, webinar. And I thank Prithvi and Shyam Prasad because when become a senior, they have been interacting with me as a chamber, as a director expert committee. When become senior, they're a little bit tough on them, but organizing various programs. Sorry, Prithvi, we're being tough on you, but I have no choice. Thanks, Prithvi, for organizing it, and Shyam and Rupa for BCIC office for BCIC secretary team. Thank you. Over to you, Bala and Sunil, for taking this webinar. Thanks a lot for participating.
Thank you, Shekhar. That was a good way to start the session. I'll now request Mr. Ashutosh Dikshit, who has the experience of the administration and now in practice, to give us a few opening remarks on the subject here, and then we'll go over to Mr. Khincha and then PVS. Over to you, Mr. Dikshit. You have to turn on your mic. You have to turn on your mic, sir.
Yes, am I audible? Hello?
Yes, sir.
Yes, sir, you are audible.
Please proceed, sir.
Thank you. Thank you. So I'll take around 5 minutes as indicated in the beginning. Let me just, start off by taking off from where, Shekhar just left off. Is this a fundamental change in the tax administration? Let me nuance it to say that I think it's a fundamental change in the operating model. Now, whether the operating model leads to a change in the behavioral model, that we have to wait and see. But let me quickly, go through what is this change in the operating model of the Indian Direct Tax Administration, which was announced on the 13th of August by the Prime Minister in what was called transparent taxation, honoring the honest. So essentially, what were the announcements? The announcements were on 3 counts. One was the introduction of a faceless assessments, both statutory as well as the non-statutory aspects, which the technology aspects which flowed through that statutory scheme. The announcement that there would be a faceless appeals scheme which would be announced sometime on the 25th of September, if I remember correctly, so sometime later in this month. And also the announcement of the release of a taxpayer charter with a statutory backing. Now, all of this, if I look at the journey, towards this faceless assessment, then I would look at it in 3 or 4 steps. One was, the baby steps of 2015 and 2016, where essentially letters were issued in October 15 by CBDT that they would be starting, in certain field formations pilots on email-based communication with the taxpayer. And this was done in, around 4 or 5 of our metros: Delhi, Mumbai, Bangalore, Ahmedabad, and Chennai. And this was essentially for only certain specific kinds of scrutiny assessments, those which related to cross-checking with the 26 AS or with the AIS CIB information which the department had. Now, if this baby step, which was just essentially talking about an interface through emails, in 2000 and this essentially was continued till 2016. Some guidelines were issued. Then in 2017, there was a technology platform which got created in the income tax department, and therefore there was an option which was given to taxpayers for opting for e-assessment using the department's e-filing portal as an option. So rather than through emails, through the portal. This was again an optional scheme in 2017. And the e-proceedings facility was introduced for time barring cases pending as on October 17. This was an instruction in 2017. Now, all this till now was essentially a technology update and certain instructions. But then we come to the Finance Act 2018, which introduced 3 new subsections to Section 143. Subsections 3A, 3B, and 3C. And we can discuss about them a bit more in detail later. But I would want to point out, one aspect which is subsection 143A, because it actually encapsulates what is the statutory intention, what is the legislature's intention, as reflected through this faceless assessment and faceless appeal scheme. It basically talked about a case where that these schemes were being introduced to impart greater efficiency, transparency, and accountability. And what was this to be done through? By eliminating the interface between the assessing officer and the assessee in the course of proceedings to the extent technologically feasible. B, optimizing utilization of resources through economies of scale and functional specialization. And Shekhar had mentioned this briefly in his introductory note. And third was introducing team-based assessment with dynamic jurisdiction. So I feel that in the public domain, there has been a lot of emphasis on the first, which was the eliminating the interface between the AO and to the extent technologically feasible, and therefore the faceless assessment. But this operating model will actually lead to, I think, a culmination only if it also leverages on the other two aspects, which is optimizing the utilization of resources, which essentially means that currently in the faceless assessment scheme, it is going to an assessment unit. But as of now, we don't see that an assessment unit is like there's an assessment unit which specializes in banking cases or in insurance cases or in other specialized cases. That would be what would be the next part of a journey in faceless assessment. And similarly, when we're talking about team-based assessments, this essentially means that that there would be interfaces between the assessment units or between specializations in order to come to a particular conclusion with regard to an assessment. So when we say this, so this Finance Act 2018 introduced these subsections, and then in 2018. We have the e-proceedings which were mandated for all scrutiny cases under Section 143. And the e-assessment scheme itself was launched in 2019. We have a next statutory amendment in Finance Act 2020, where Section 144 was also added and under the scope of this e-assessment, and also penalty proceedings. And also, the legislature enabled the executive to also take appeals also under an e-appeal scheme by amending Section 250. Now, all of this culminated in, as I said, in this August 2014 announcement, where there have been a substantial number of notifications which have been issued. These notifications essentially now create two types of jurisdictions, the dynamic jurisdictions which are talked about. One is where even though there may be an assessing officer who has a territorial jurisdiction, but the assessments will be done in some ways in a functional form through this faceless assessment scheme. And then the post assessment, all of those functions would still remain with the assessing officer. So that what we would call the residuary function, that is what is being called. So there is definitely a change in the operating structure and operating environment. My own interface with the department officials shows that at least at their end there are apprehensions, there are questions, but definitely there is movement towards creating this operational structure. I think this first year will raise a lot of issues. I think also technology issues. And I think which we need to constantly interface with the department with regard to sorting out these particular issues. But let me just stop here And or before I would want to mention that this faceless assessment scheme essentially has now a structure where you have a national e-assessment center, which is going to be the interface between the taxpayer and any tax authority. And it's like a hub and spoke model. It will be assigning cases, issuing scrutiny notices, and then assigning those scrutinies to different assessment units, which will be through different REACs in the country. And even the assessment unit will be leveraging a verification unit. There will also something which is called a technical unit, which is supposed to render technical advice on certain specific matters. And then there is also a review unit which will review assessments based on what the NEAC has mandated. Not all of them will be going for review, but they will have certain checks and balances where they would want certain cases to go for review. So this essentially is the functional characteristic which has been created. Let me stop here and hand back to Bala.
Thank you so much, sir. Padam, your insights.
Sir, your mic needs to be on, sir.
Thanks to BCIC for giving this opportunity to participate in a very, in my opinion, an important topic for all of us as corporates particularly. Shekhar began with some amount of trepidation to say the scheme is fine, but outcomes are unlikely to be good. Possibly it's coming out of past experience. When you extrapolate your past experience and look into the future, you find more negatives than positives, and therefore possibly the experience in the recent times have led to this type of a feeling. Obviously, also because in my opinion, the question is about intent versus implementation. Your intent may be good, but what happens in implementation is an issue. Before going to the negatives of the scheme, therefore, let us look at some positives also, because there are certain positives in the scheme, and I'll do the macro level positives of the scheme. We'll get into some minor micro level details over the period of our discussion. But this is an attempt to have a paradigm shift in the process of handling the assessments of corporates and individuals. Extremely important paradigm shift. The shift is so important that the Prime Minister found it himself to come onto the stage to say, I'm introducing the scheme. That means it went beyond the ministry, went up to the Prime Minister. He came forward to say, I'm going to introduce the scheme. Possibly, therefore, he attaches importance to the scheme. He therefore thinks that this should be a change that should come about in the entire mindset of the department concerned. It's a situation where, therefore, we are going to have an embracing or imbibing of technology. This is important. This is a very wonderful step from moving from an archaic system to a modern system of governance. International standards are being exhibited. As a result of this, therefore, we are going to have some sort of a situation where, if these things are very well implemented, it's likely to boost the confidence in the industry. And there's going to be, therefore, an enhancement of ease of doing business in this country, if that were to be the right spirit in which the scheme is implemented. We're also moving from an individual work to a team-based work. Issues of the industry are complicated, not very easy to handle, and therefore it's not possible for an individual to handle these issues. We therefore are moving to a team-based work. Therefore, that's a positive development. The moment you go into a team-based work, what will happen therefore is you're going to have some sort of a experience that is going to come up, industry-wise experience. There's a great possibility now that we could have situations where experience per industry or for a particular domain of work would be available within the department concerned. This also is backed up by the fact that the department is having a good amount of data about an individual today. Information is coming seamlessly into the government, both from within the country and from outside the country. The department, therefore, is able to have a 360-degree profile of an assessee concerned, giving the confidence to the department that, look here, I'll give you a pre-filled form. That's the confidence the government is projecting now through the use of technology to say, I'll have a pre-filled form. If you don't agree, fine. If you agree, because I have information about you, possibly more than you have it yourself. And therefore, that's a situation where, as a result of this technology and the profiling the government is able to have, this is possibly a step by the government. I don't know. It appears to be that they're going to reduce the number of scrutiny. Possible. It's a situation, therefore, that we are moving from a discussion-based assessment to a submission-based assessment. There's going to be a situation where there's going to be a saving of a lot of time. There's going to be an avoidance of unpleasant experiences we've had or interactions we have had. And this also has an issue where this scheme, if we are to be implemented in the right spirit with which the taxpayers charter has been introduced and the various rights given to us under the charter, in my opinion, therefore, a combination of the taxpayers charter along with the intent, along with the spirit behind the faceless assessment scheme, that combination can bring about, in my opinion, a wonderful shift in terms of the experience of the assessors when they interact with the department. This also is going to have some sort of an increasing role of professionals, because you're going to make submissions. You're going to be ensuring that there's going to be some sort of a expression of your ideas very precisely, very correctly when you make a submissions to the department. Therefore, the role of a precise or a precision in terms of drafting, precision in terms of explaining, precision in terms of submitting is going to be extremely important. Having talked about positive, what are the negatives? And negatives are mostly based upon the past experience. There could be some negatives from out of the scheme also. I'll have an occasion to refer to broadly at the macro level, some problems within the scheme at a macro level. Situation therefore for us is, as Ashutosh was mentioning, the three objectives are to ensure efficiency, to ensure transparency, to ensure accountability. If you go into the entire faceless assessment scheme, it only talks about efficiency. There's nothing on transparency, there's nothing on accountability. Therefore, those two aspects are missing. All that we are doing now is looking at how income tax department within its own functioning is possibly trying to or attempting to be more efficient. How is it going to be transparency? How is there going to be accountability? Possibly because when you have a team-based work and the way the scheme is so designed, you don't know who is the captain of the team. You don't know whom to place the blame on. As a result of it, therefore, the question of accountability, the question of transparency possibly have not seen the required emphasis in the scheme. They're only making a situation about how are we going to utilize the resources of the department in an optimum manner. We've had the past experience. We've had the experience of LTUs. They thought it was a great scheme. Look at all. We'll have a combined or direct indirect tax impact. Nothing happened to the LTU scheme. We had the DRP scheme saying, oh, 3 commissioners, the best of the functionaries will be there to handle assessment. We will therefore ensure that department has no right of appeal. What happened? Very difficult. Nothing happened. CPC came in. Wonderful in terms of refunds, in terms of processing. But then the interaction between the CPC and the regular department is a very sad experience. What mistakes CPC does, nobody is willing to take responsibility of rectifying those defects. Ombudsman, grievance, what happens? Nothing is happening. It's all there in the letter of the law, not there in the spirit to be implemented. Therefore, the question is about the existing scenario, attempt to change the functioning of the department have not had great positive responses from the tax-paying community. And therefore, the question therefore is this also a situation where this scheme is being thrust upon the tax, even the tax officials from the top? Therefore, a positive statement, let us say from the IRS Association, to say we welcome the scheme, we will see that it is a success. Nobody is coming about with that. It's being thrust upon them. Therefore, the question is, when there is being thrust upon the IRS officials, if they were to resist, if they were to therefore ensure that the functioning is in such a manner that they're not going to be allowing the scheme to be a success, the entire intent and purpose of the government is bound to fail. That's the way the whole scheme has happened in DRP, in LTUs, ensuring therefore that we have had to a situation where assessments are not being fair, assessments are not being, in my opinion, justifiable on the basis of the facts and circumstances. As a result of it, therefore, today we have a situation where we have the highest rate of tax disputes, highest amount of tax disputes, with the lowest rate of recovery from those tax disputes. That's a very unfortunate statistic. Highest amount of tax disputes in the world. The rate of recovery from out of the tax disputes is very, very low. This is extremely a fundamental factor for us to address, and I don't know whether we'll be able to. Through this scheme, intent is fine, but in the implementation will not to be in accordance with the spirit of the scheme, it's going to be extremely difficult. Shekhar was mentioning about one of the aspects of the bane of the tax department was target setting. Other banes are vigilance, the problems of vigilance. Other banes are about audit internal. Other banes are about the aggressive attitude of the tax department. Therefore, the heart of the issue, the manpower issue has not been addressed. In my opinion, the scheme is going to give us new types of issues coming about, because the interface between the units concerned is going to give us to a new amount of issues in terms of timelines, in terms of litigation, in terms of jurisdiction, in terms of overlapping, who has the role, who doesn't have the role. There won't be a lot of dispute, because when you look at the scheme in particular, you don't find a clear-cut demarcation about the various roles and responsibilities. There appears to be some sort of a overplay between the various functions and roles concerned. We'll have occasion to see that little over a period of our discussion. But what's important to notice is that there are going to be therefore new types of issues. The existing provisions of statute have not been addressed properly. There are so many other provisions of the Act which still have to have an interplay being properly designed in terms of how they would interact with the new faceless assessment scheme. For example, what happens to a valuation officer under 142A? What happens to an additional commissioner who give direction under 144 capital A? They have not been properly addressed. We'll therefore have some sort of connectivity issues. We have some sort of technology issues. We therefore will have a situation, in my opinion, the most important aspect of this is that the department in its brochure, in its publication, are saying 68% of the officers will move to the faceless assessment scheme. 68%. Now, as it is at the existing strength, we have a huge amount of pressure. Assessment order being passed on the last day, last minute. Are we therefore going to have a similar number of assessments with 68% only strength going? Is there going to be a situation where therefore, let us say, for example, the review units of the tax department in the faceless assessment scheme will be extraordinarily burdened because everybody will say, you review your job, your responsibility, you give me the answer to that, your responsibility. And therefore, the organization strength, the way that this has been distributed or conceived of, in my opinion, leaves a lot to be desired. There are very interesting issues that all the communications between the various units concerned, they are a part of the assessment records, in my opinion. Now, therefore, if my assessment is complete, and would I have access to all of these records tomorrow? Because the review unit, the technical unit, the assessment unit, the verification unit, they have conducted inquiries in my case. They should form part of my records. Because tomorrow, if 148 were to happen, if 263 were to happen, I should have access to these records concerned. And therefore, the scheme is unclear as to what will be made available to the SSC, what will be the way in which I should be able to obtain information on this matters through RPI. In my opinion, therefore, as an attempt, the concept is very good. We therefore have to look at the way in which it is going to be actually implemented. And that, is, in my opinion, is the key to the success of this faceless assessment. Thank you.
Oh, thank you, Padam. PVS, over to you. We're running out of time. Brief comment
No,
from PVS.
I'll take only a couple of points. Others have said, I don't want to repeat it. We have to start with an understanding that income tax is a self-assessment scheme, that the assessee himself assesses his income, pays the taxes. My understanding is that substantial taxes are today paid voluntarily, that is, by the taxpayer himself. So the question is whether this new method of assessment is going to reduce the number of assessments which will take place, or it is intended to reduce the amount of litigation associated with the assessments. My guess is that the number of assessments may come down. The question is whether it will reduce the litigation. I'm not too sure, because now you have put it to a little wider group of judgment. Very hardly you get two experts agree on a particular view. And when you have a panel trying to agree on a particular view, you may find that the agreements are quite not easily reachable. I would place only two decisions of the Supreme Court for a technical discussion so that we can commence our other questions. There is a decision of the Supreme Court called Radhaswamy Satsang, which says that there should be consistency in the assessment. That is, if one assessment has been completed in a way, subsequently with the same set of facts, the next assessment also should be the same way, even if there are certain acceptable errors for a moment. So you will say that Radhaswamy Satsang is one decision which I want to look at it, how it will operate. Number two decision is the Berger-Paints. Berger-Paints says that if you have not appealed against a particular decision in one jurisdiction, you are not entitled to disregard that decision for another assessee in another jurisdiction. Now, if national e-assessment is the final focal point, that means that any e-assessment which is the central focal point or the hub of the entire assessment, that should necessarily apply whatever favorable decisions has been held in one assessee, it should be willing to extend to any assessee across the country. So I would say these two decisions, how you are going to place it, the rule of consistency and the rule of uniformity. With that, I will leave the discussion for you to take it forward.
Oh, thank you, PVS. I'll start off with you, PVS. if you look at the timeline, people may say that this faceless assessment has come too soon. But if you look at the journey of electronic adoption, the digital adoption in income tax department, that has been there for quite some time. What is your view on that, and how has been our experience on the electronic adoption? While Padam and Shekhar talked about various experiences on DRP side, on LTU side, on the technology side, how has been the journey so far, and how has been the impact?
Bala, we will recall, even Mr. Ashutosh Dixit did refer to some of the technology initiatives while he made. So I will not repeat to the extent he has already said. The e-return filing mechanism, some of them mandatory, started as early as in 2006. So you can say the electronic gathering of data by the department happened in 2006. Now you have got CPC, which is Padam did refer that electronic processing is happening, refund is happening, but nevertheless it's not creating a what's called adoption by the department. It looks like a service provider rather than a department owning the CPC. Now you have got some to say that actually the e-assessments, though it was conceived, it was supposed to be implemented by 2022. My guess is they have advanced it because COVID has come. There are already e-hearings which are happening as high as the Supreme Court hearings are now taking place as e-hearings. And there is some effectiveness about these hearings. We may say this is not as effective as physical hearings, but still justice is being dispensed with in a fair manner. So there is some amount of success with e-hearing. And our own practices with e-assessments, I will say the selective, limited scrutiny, full scrutiny, all these have worked reasonably well. I think if I have to tell you, the limited scrutiny has been more often limited to the scrutiny they have selected. They have been able to conclude assessments. These are good experiences, I will say. So the e-assessment, though it's with a jurisdictional officer, it's not a dynamic one. But e-assessments has worked well for most of the small assessees. Large assessees still have face-to-face because they prefer it that way. But I would say the electronic initiatives so far have been reasonably successful. There are certain glitches because if you have got an old demand, it never vanishes because it's already there in the CPC recovery list. So people keep on pushing a demand notice on you irritably so, but the demand may not be there, you don't have the documents. But these irritants, the department is unwilling to handle it. I will say electronic method of communication has an advantage, but a disadvantage too. Today, you can't even go to the department to solve some of the issues, even though you feel a face-to-face mechanism would work often. So we will possibly have some teething problem with this assessment scheme. But any initiative should be welcome as long as it's intended well. The implementation will be forced by the citizens sooner or later. Bala, back to you.
I'll take that over, sir. Thank you for your comments on that. Let me just move to Padam, sir. Sir, I think there are amongst the opening remarks, really two different aspects that we need to look at. One is the practical side in terms of
Bala, Sunil, we've lost you. Not able to hear Sunil. Not able to hear Sunil. Hello.
Sunil, we are not able to hear you. Sunil, we are not able to hear you.
Sunil, not able to hear Sunil. You're not able to hear Sunil.
Sunil, we did not hear you. You have to ask the question again.
Can you hear me now?
Very feeble. Not very loud. It's very feeble.
Is this better?
Come a little closer.
Can you hear me now?
Again, feeble, but okay, a little better. Feeble, but.
So let me try and speak aloud. Adam, sir, I was looking at the assessment, and there are two aspects of it. One is the legal aspect, and one is the practical side in terms of interaction, engagement, etc. Wanted your views on how robust the framework do you think the legal framework is in managing the whole e-assessments. You touch upon roles, responsibilities, etc. So how good do you think the legal framework, the way it has been set up, and you think something more can be done from a legal framework for the e-assessments?
We have had an issue in terms of how the scheme is going to span out. The features, therefore, would be that there has to be an e-communication. There has to be an e-confirmation of the communication received. There has to be an e-verification. There has to be an electronic response. This is the way in which the features of the scheme are largely designed. And what's going to happen is, therefore, the selection of this case would happen through the system by automated algorithm. It is also going to have allocation of cases could happen automatically by the centers, the National Assessment Center, through the various units concerned. There's going to be a central issuance of notice. Now, if you look into a historical evolution of the statutes in terms of jurisdiction, we had a situation where assessing officer were having either a jurisdiction on an assessee based on its territory, based on the place of carrying on business, based on the class of incomes he had, or based on the class of persons in which the assessee was classified for the purpose of conferring jurisdiction on tax officers. This is the traditional way. Now, when you say that no, all assessments shall henceforth be done by the National E-Assessment Center, the question arises, you need to have some modifications done so that you have to divest your jurisdictional officer concerned and place the authority with somebody else who is going to be now statutorily empowered to commence the assessment process and issue all notices, take decisions also. What they have done is, as Ashutosh was mentioning, they have said that 143, they have introduced sections to say that various provisions of the Act may be modified, may be adapted, may be ignored, may be molded to ensure that effect has to be given to the faceless assessment scheme. What therefore the government has done is, it has given a notification concern. For example, it has said, who shall be an assessee under section 2, subsection 7, under section 120, under 124, who shall be your assessing officer? What will happen under 127? What will happen when there is a shift of jurisdiction? 129. Who will conduct the survey? 133A, 133B, 133C. Chapter 14 that deals with the entire assessment process, and chapter of penalty, chapter 21 of the Income Tax Act that deals with penalty. What they've done therefore is, they have said these are the specific sections that shall now operate in accordance with the scheme concerned. Therefore, you can't go back to the relevant provisions of the statute. You will have to therefore go by the provisions that have been enshrined now in the scheme, in my opinion, in derogation of the provisions in the section that I have outlined. Therefore, they have had a notification issued now to say that these provisions, the various numbers I mentioned out, particularly chapter 14 and chapter 21, they shall stand modified by the provisions in this scheme concerned. What's going to happen therefore is, you're going to have a situation where the government feels that by its experience over a period of time, it may find some more modifications required to be done. Some more provisions of the Act may have to yield to the faceless assessment scheme. Therefore, waiting for its experience. And what it has done therefore is, through the Finance Act 2020, they said our ability to change the existing framework of law to mold itself and to yield to the faceless assessment scheme, we will reserve our powers now up to 31st of March 2022. So therefore, they could make further changes to the scheme of the Act up to 2022 based on their experience concerned, to say that these provisions of the Act, other than the provisions they've already notified, how will they start subsuming themselves or yielding themselves into the faceless assessment scheme. They've also made a situation that, apart from this, 282 that deals with service of notice, how to serve notice on a person concerned. So 282, 283, 284 of the Income Tax Act, they specifically deal with the method and mechanism of servicing. Rule 127, Rule 127A of the Income Tax rules deal with the mechanism of serving of notices concerned. They said even these sections will have to yield to the provisions made in the e-assessment scheme. And lastly, they have said the provisions of appeal under 246 capital A, the provisions of appeal will continue to be a situation that you will have to be said to be continued to be assessed by the same officer under whom you were originally assessed. So what happens is, your scheme moves to the national reassessment scheme for the purpose of completing your assessment order. But then the order will come back and say, oh, it is now order passed by the jurisdictional officer under whom you were originally assessed, such that your commissioner of appeals will depend upon that officer whom you were originally assessed by. And therefore, who will be the commissioner of income tax appeals will be governed by the very same officer who was originally handling your assessments. Therefore, they have made adequate provision to ensure that your right of appeal will stay vested with the same jurisdictional commissioner who had jurisdiction over you. So what they have done therefore is they have made some effort in identifying these provisions concerned which have a bearing on assessment, and they have made appropriate procedures in the law for this purpose now. We'll have an occasion to come back specifically, in my opinion, to the personal appearance. That will be a little later. But I thought broadly, the scheme of the law is such that having gone through and scanned through the provisions of the Act, they'll be able to identify various provisions that may have a bearing on the faceless assessment scheme. And therefore, they said, we reserve our powers, therefore ensure that those provisions of the Act shall get appropriately modified and will have to yield to the provision as mentioned in the faceless assessment scheme.
Thank you, sir. I think the only concern or issues that as taxpayers that we will have is, how stable the legal framework is going to be, because one thing which has been the Indian tax system is with the frequency with which changes happen. We've always asked for certainty and stability. So I'm hoping that this has been thought through from a legal framework perspective, and it doesn't, keep changing, often as we proceed along. So I think, let's wait and watch.
I thought so. Therefore, I only gave the macro outline. At the micro level feature, there are certain issues. We'll have to come over a period of our discussion. We will see as we come about.
Sure. Thank you, sir. I will move to now Ashutosh, sir. So, given your background with working with the government in terms of policy formulations, it will be interesting to hear how do you see the income tax department, the landscape over there changing? Do you think they're completely geared, for such a change? Typically, in the corporate world, whenever there are these changes that happen, there is also a lot that is thought about the transition. For example, I don't know whether all of the information related to a taxpayer have now been, where it moves to. Does that person have all of the records, all of the information? That was just one aspect which has come to my mind. But like to hear as to how you see the tax department geared and the changes that you would see in the landscape of the tax department.
Thank you, Bala. So I would, my own, I see the way the announcements have come about, and also my own interaction with departmental officers, and historically how I've seen, changes coming about in the income tax department. I would have no hesitation in saying that this is a top-driven approach. Now, is that necessarily bad? You see, one difference between commercial organizations and a regulatory or a statutory organization is that many times you see that the channels of communication are also hierarchical, and some of these things perforce have to be so. So, so to that extent, yes, this is definitely, in my opinion, top-driven. That is not necessarily, a bad thing, because when we're talking about bureaucracies or government bureaucracies, the hierarchies are in some cases ordained and needed. But yes, even in that aspect, the whole cultural change which needs to take place, that definitely, at least in the Indian context, has always lagged the technological change. To that extent, I think this scheme also is going to follow that particular path, where it is the technological availability in order to do faceless assessments, which has driven this in that sense, and that the organization's own cultural aspects and in terms of interactions they will definitely take, or follow or will follow through a time lag. How much that time lag is I think what we are all discussing in terms of, when we talk about intention. The other thing is, and Padamji had mentioned this, is that 66% of close to 66% of the officers have now been moved to this to what you call this faceless function or faceless assessment function. So let me say, that in terms of functional, what we are actually seeing is that at a broad level, there are now within the department, they have now created two functions. One is the faceless function, and I suppose faceless appeals will also follow, by the end of this month. And the other is what they're calling the residual function. But from what my interaction with officers has been, is that their own feeling is that actually it is the residual function which takes up much more time rather than the assessment function. And I think perhaps, with a bit of learning, this 66-33 may move closer to 50-50. But we'll have to wait and see, because a lot of the interface which and the struggles which we as taxpayers face are with relation to, a lot of other things outside assessment, like getting an appeal effect done, getting a rectification order done. As Mr. Srinivasan mentioned, there are a lot of demands which need to be extinguished in the system, but which are still hanging around like ghosts. So all of those things actually need a lot more attention. And perhaps in some ways, if the number of assessments gets reduced because of this, and I only know that some e-assessments have happened through this faceless scheme or this partially faceless scheme. I don't know what is the results in those cases. Whether I don't think we've been able to do that comparative between how much time those particular assessments have taken and what are the kind of additions which have happened. But if that does really lead to lower number of assessments and a lower number of what I would say is incongruous type of additions, then the department should be able to take much more time on the residual function and give that taxpayer satisfaction which is currently lacking. As Bala, do you want me to talk about the structure itself, the NEAC, REAC, and the assessment units, verification units, review units, technical units, or do we cover that in a subsequent question?
Yeah, we can cover that in a subsequent.
Okay, right. Sorry, Sunil. Yeah, thank you for passing it back to you.
Thank you. Thank you, sir.
Thank you. Thank you. PVS, coming to you, one of the thing that we are also interlacing with this faceless assessment is this honoring of honest taxpayers, right? And Shekhar briefly alluded to what does honoring a honest taxpayer mean? Is it like bringing a charter? Is that or providing taxpayer services, an administration which is simple, which is fast enough in terms of the appeal effects and the demand extinguishment of the refund processing. So what are some of the things that you would cover as pillars of this greater policy of honoring the taxpayer, honest taxpayer?
As far as the faceless assessment, there are two things. One is a charter, and the faceless assessment scheme is an enabler for the charter. Let us see how the faceless assessment is going to work. If honoring the honest, what it looks like is that more often when you file your return, and the data which is already available with the department, they are all collected, they are all aligned to the data you have furnished in your return, and if there are not gaps, then possibly they may not even pick you up for an assessment. They may proceed to frame the assessment, close it. So I would say honoring the honest here is to accept the return as you file. If you are a honest taxpayer, the more often your return gets accepted without even calling for a scrutiny assessment, I think that would be the first step to say you are honoring the honest. And if this system is going to result in reduction of even the scrutiny assessments, which are today most you find even in the current scheme, the people who are selected for scrutiny, or those who are repeatedly being selected for scrutiny, they are actually the taxpayers in the country. They are the ones who have been paying from time to time more honestly than many others. But you find they are the ones who are subject to litigation also. My sense is that the government will limit the amount of scrutiny to those who are filing the tax returns, accepting the returns, accepting the amount of income they are duty bound to return, and the evidence which is available with the department corroborates to the return they have filed. I think that will be the honor. Automatically the refunds would apply, the service would happen, there won't be any demands to collect, there won't be any pending refunds, therefore there's a honor for the citizen. So ease of doing business, if you keep it as a overarching requirement of the country, it would do well. The downside of this is that very large assessees invariably will be automatically selected for scrutiny assessments in this. It will go through the national e-assessment channel. Quite possible that each one of them will be sent to the verification unit, the technical unit, even the review unit for a moment. Assuming that if somebody has to go through the review unit, that it is not the old unit which got selected, it will be another unit, altogether a new person who will come. Possibly the review will be limited to the issues which are sent for review, but we do not know it could cover the entire scope of assessment. Also, we do not know at this point in time. Whether the review unit is the audit function today, I have no idea. There is an audit today already happening on the what we call as revenue audit, which is already happening. Whether it's a substitute for revenue audit or it's different function of review, it's not very clear. But essentially, I would say those who have got large assessments to handle will have the rigor of this e-assessment a little more falling on them. Small and medium assessees who have all found that the details available in public domain are all collaborated and then put into the return, considered properly in the return, I think they will have an easier life. So I will say the government will focus on the large assessees a little more, and those who are not filing the returns properly, they will be put into the net. So honoring is negative, that I will try and chase the ones who are evading, therefore the one positive ones get honored.
Okay. Thank you, PVS. Padam sir, on Mr. Dikshit also covered the issues of the primary function and the residual function. So when you come to the residual function, that is going to vest with the jurisdictional officers, if I may say so. So what are those exclusions from the faceless assessment, and what is going to vest with the jurisdictional officers?
We will have to understand your question from two angles. One is from the angle of the provisions that are there in the scheme, which make very clear that some provisions can go back to the jurisdictional officers concerned. And the second part of the story would be on the basis of a circular that the board has issued. This was issued on 14th of August 2020. A circular was issued to say that the following functions shall be continued to be handled by the residual or jurisdictional officers concerned. So what are the provisions under the scheme we look at? Interesting, it says, if an assessment has been completed by the National Assessment Center and a 148 notice has to be issued, the scheme says it shall be issued by a jurisdictional officer, it shall be issued by a residual officer, will not be issued by National Assessment Center. That's the provision we get specifically from the scheme itself. Now, one is the inferential reading that the penalties that can be imposed under Chapter 21, the NEAC, National Assessment Scheme, will have the right to levy a penalty only in relation to those offences pertaining to non-compliance with notices or directions. That's all. All other penalties will continue, therefore, inferentially to be levied by the jurisdictional officer concerned. So, second, there's an explicit provision, Rule 5, Subrule 2 of the scheme says that the NEAC may pass your case back from the NEAC to the regular officer concerned, and no reasons have been outlined. Very interesting. They say that we may therefore push your case back to the jurisdictional officer concerned, and that way to happen, then obviously you'll have an interaction with the jurisdictional officer only. That's a scheme available, provision in the scheme itself, that your case may be pushed back to the jurisdictional officer. These are three. Now, there are other important provisions which are coming about from the board circular of 14th of August 2020, and they are very interesting to say that your 154 applications, your refund applications will continue to go back to the jurisdictional officer concerned. NEAC passes the order, all appeal effects all refunds, all rectifications go back to the jurisdictional officer concerned. 263 and 264, these revision powers will remain with the jurisdictional officer. That means the CIT, who is the jurisdictional CIT, will have power to have a 263 or a 264. Such cases will be outside the faceless assessment scheme. Importantly, they're saying tedious provisions, tedious jurisdiction for the time being. This is a board circular saying tedious jurisdiction will continue to remain vested with your jurisdictional officer. They're saying people who are now international tax associates, international non-residents concerned, those people will be outside the faceless assessment scheme. Then you also have a situation where your grievance handling will happen with the regular officer concerned. The prosecution will happen by the regular officer concerned. The custody of records, if you want to have obtained some portion of the records concerned, the custody of the records will be with the regular officer concerned. The management and control of infrastructure also will be with the regular officer concerned. That's an interesting statement, that the infrastructure control and management will be with the regular officer concerned. Taxpayer education, taxpayer facilitation will be with the residual charge, jurisdictional officer concerned. And these are, therefore, the HRD functions will be with the residual officer concerned. These are some of the functions explicitly mentioned by the board in its circular that they shall remain with the jurisdictional officer concerned. If you look at, therefore, the conspect of the powers, you find that you will be governed today, in my opinion, in a large number of measures, both by the regular officer as also by the faceless assessment national NEAC. And therefore, possibly there will be a multiplicity of interactions of an assessee concern. And one of the concerns for the industry, say, will compliance costs come down? Will my need to meet various people come down? In my opinion, as on date, that doesn't appear to be very likely.
And sir, if I may just have a follow up on this, what would be the control of the jurisdictional officer on the person who is passing the order, or one who is reviewing the order? Would he have some interaction? Does he have any authority? Because you said that the final order is going to go under his name. So if he is not agreeing with what is mentioned in that order, does he have the right to differ with the assessment unit and the review unit? And so what are the powers vested in the jurisdictional officer in that sense?
Once, if you look into the scheme, there's sort of a yo-yo, goes up to the NAC, goes to the UO unit, and if you try to pass them, there are multiple draft orders visualized, multiple draft assessment orders depending upon the review that happens and a modification that is proposed. Therefore, if that were to happen and it goes to assessment unit, it goes into the verification unit. What they're trying to say is that the National Assessment Center will have a risk management strategy. They'll have some software. They'll have also a situation. The definition is about an automated examination tool, and a risk management strategy. These are going to be deployed to ensure that what happens is that the discretion available with various authorities concerned is minimized or eliminated. And this will therefore say, because before that, the verification unit will say, all judicial decisions have been brought on record, all facts have been brought on record, all issues have been adequately discussed, all provisions of law have been properly put into place. That is the job. Arithmetical accuracy has been checked. This is the job of the verification unit. They have to therefore ensure that these are things that have already been incorporated. Now, coming to a critical question, who takes the onus of the responsibility to say that who shall do the assessment? Because interestingly, the National E-Assessment Scheme does the final job of issuing the assessment order, but it does not do any functions of assessment. The assessment unit will do it, the technical unit may do it, the review unit may do it, or the verification unit may do it. Nobody is taking the responsibility. Therefore, I made a statement initially. Who is the captain? Who takes the responsibility? Who will take the job of ensuring that the dispute between the various principal commissioners in relation to the respective units, how are they going to be resolved? We have some provision on 127 of the Income Tax Act, right? In my opinion, this is going to be an issue today for which we have no specific answer. They'll possibly have internal guidelines on this matter. They'll therefore not make it public to the people at large to say that the protocols or the systems and processes to be adopted internally as to the hierarchy of these units concerned and who will take the ultimate responsibility will possibly be done by them or by a notification or internal guideline that will happen.
Thank you. Thank you, sir. I'd like to get your comments, sir, Ashutosh sir, on the same point, because from a government perspective, how do you see this working? Especially on how would the automated allocation process work? We spoke about will there be industry experts? Is that how the allocation will happen? And how would this, your view on what Padam sir said about the yo-yo happening between the different units under the national e-verification, e-assessment center and the jurisdictional officer? Your thoughts on this?
Yes. Just taking this forward, essentially, if you look at it, we are right now with this scheme and this technology backbone, we are somewhere what we call in a halfway house, because in other jurisdictions across the world, when we talk about functional, there is no actual, assessing officer whose name or designation appears mostly in the orders. It is passed under the seal of the commissioner, of income tax, and that commissioner is supposed to be the heading the entire organization, of that department. But here, if I look at it from a functional point of view, as I had mentioned, broadly, there is one kind of functional, differentiation which has taken place, which we would say, the assessment, which is faceless assessment, and then the residuary, powers. Now, the intention seems to be is that if you look at, I had mentioned, the three aspects of the scheme under 143A, the statutory, is what they're calling a dynamic jurisdiction. I think what they mean by the dynamic jurisdiction is that the assessment function, oscillates to somebody who is not otherwise the territorial assessing officer, but then the post-assessment functions then, oscillate back to the ones who is the territorial assessment officer. That seems to be the intention. As Padamji mentioned, there may be certain gaps, in the way this has been formulated. I think going forward, that is why that power has been taken, a statutory power where they can modify certain sections to be read in accordance with, with this kind of a functional differentiation. The other aspect of the functionality is that even within the assessment function, that has also been sliced and diced. So in the sense that you do have an assessment unit, but if that assessment unit wants to conduct a verification, it has to pass on a request through the RESC to the NESC, and the NESC will then get the verification conducted through another unit. Similarly, if the assessment unit wishes to, take some technical opinion on an issue which they feel that they need advice, then there are these technical units, and again through the NESC, this will get sent to the technical unit for whatever advice which has been sought. And has been mentioned, in all of this, even the draft assessment order, even once it has been formulated by the assessment unit, they will have some risk management systems which have not been, as of now, is supposed to be automated. What that is not in the public domain, but they may run this through, and therefore some of these draft assessment orders, how many one doesn't know, but they will go to review units who will review it, and in case the review unit suggests some change or whatever, then this whole process of taking it back to the taxpayer and taking the taxpayer's response and all will happen. So the assessment function itself has also been sliced and diced in that particular manner. So two levels of differentiation in the functionality of it. Now, if we look at this from this point of view, then it seems that unless, as was mentioned, the NESC takes a view and and sends, in some cases, sends the entire assessment back to the so-called jurisdictional assessing officer, which I think would be a very, very rare circumstance, because they would have to, I think, go back to the board and it would only be in one-off circumstances. So you would have a case where the so-called jurisdictional assessing officer really has no major role in the assessment function, but he will have all the other roles of collection of revenue from that particular assessment order, in terms of any rectifications which have been noticed and all those kind of things. So, going back to that particular point about whether the same assessing officer who has the charge of collecting the revenue or has a revenue target, whether he will actually be also doing the assessment, then that has been what we call split up. Now, even on the appellate function, like I said, we are still halfway house, because on the 25th of September, the similar intention seems to be with regard to the appellate function. So the CIT appeals, again, it would essentially get sent to a CIT appeals who may be in some other jurisdiction. It would again, we follow that same kind of scheme which is there in the assessment function. So I would say is that we will have a situation where, especially for large assessees, as was mentioned by large taxpayers, was mentioned by Mr. Srinivasan, where we will have to be much more focused in terms of our responses in these through this faceless assessment scheme, because there is not going to be, as we said, there is not going to be discussion, there is going to be submission, and there are timelines. Within 15 days submissions have to be made, and if the 15-day rule is not followed, we have to ask for further deferrals or further time. And if you don't follow those timelines, the NEAC has also power now under section 144 for a best judgment assessment. So to that extent, even on the side of the taxpayers, that function, that specific attention to submissions in an assessment function will have to come about. I think that will also have to be followed through in the assessment, in the appeal stage also, because it will be a faceless appeal. And there would then be a separate interface with the jurisdictional assessing officer, who may actually, in some cases, and there also what they're saying is that interface should also be faceless. To what extent that will happen, I'm not sure, because a lot of these nitty-gritties which need to get done do need some discussion, whether that will have to be virtual. Those things are still awaited. But yes, what I would say is that this is definitely a new paradigm, a new kind of interface, and although we have had some experience of it, I would still await what is the result of the faceless assessments which have already happened, actually during the course of the year, the partial faceless assessments, what is the taxpayer response to that, what has been our interface on those, what has been the outcome, and then see this going forward.
Thank you, sir. Padam sir, just coming back to you, we did briefly speak about this. The personal appearance, this is something that we have been very used to in the assessments that we've done for so many years and decades. How do you see that working? Because a lot of the discussion that we are having seem to be only on submissions, robust submissions, well-drafted submissions, etc. But we know that even in the past, in spite of well-drafted submissions, personal appearances have been very, very helpful, especially for complex matters, large organizations. How do you see this now, working in the new model that we have?
Go back again to two propositions, in my opinion. One is through what is there in the scheme and what has come out in the circular. There are two provisions in the scheme. One is the provision mentioned in Rule 5 of the scheme, and the other is the provision mentioned in Rule 11 of the scheme. What happens, therefore, under Rule 5, they say that all the interactions between the various units concerned shall only be by electronic mode, except in the case of verification units. There could be a situation where they will forego the electronic communication mechanism, possibly have an interaction. So Rule 5 is making a provision that the verification unit can have a personal interaction. For example, if summons have to be issued, statements have to be recorded, books have to be examined, possibly. Books have to be examined, possibly. Those could be circumstances where the NESC will design out those circumstances under which the verification unit could go and make a personal interaction with an SSC concerned. That's interest between the department. As far as the SSC is concerned, Rule 11 of the scheme says there shall be no personal appearance at all. Now, having said that, 11.3, sub-rule 3 of Rule 11 says that if there is a request made that there are particular points that we would like to be making a personal presentation about, then the principal commissioner of the regional assessment center will have to list out circumstances, under which there can be a facility for a personal appearance. Now, that personal appearance shall also be limited to video conferencing. It can't therefore go and meet them. It shall be by way of a video conferencing. And those, therefore, Rule 12 of the scheme says that the regional assessment center over a period of time will outline circumstances under which the request by an SSC for a personal appearance, that means personal appearance through a video conferencing, shall be acceded to or granted. That those circumstances have to be outlined. So let await those instructions concerned. This is one part of the story. Now, the circular 14 of 2020 is interesting. It says that all this is fine as far as the scheme is concerned. As far as the residual jurisdiction is concerned, we have seen so many functions to be performed. How should they be performed? Now, the circular of 14 August says, very interestingly, it shall be done in a faceless manner to the extent possible. Very interesting. To the extent possible, it shall be done in a faceless manner. They're not mandating it shall be in a express manner, explicitly by a faceless manner. They're saying to the extent possible. Who shall decide to the extent possible? Anybody can decide to the extent possible. Therefore, interesting that the board circular is already drawing out leakages from the main scheme to say that to the extent possible, the residual officers shall conduct these proceedings in a faceless manner. Otherwise, it shall be a personal hearing that can happen. Not even necessarily a video conferencing. It can happen otherwise also, because there's nothing mentioned there in that board circular to say it shall necessarily be by video conferencing. One important provision that they are making is that if you do not have the ability to have a video conferencing, the government will set up video conferencing facilitation centers where you could go and utilize those facilitation centers for the having access to technology, such that your video conferencing presentation or a request which is acceded to, you could you could go to the facilitation center and make use of them and make a presentation through the video conferencing facility.
Is it then to be assumed that the taxpayer doesn't have a right of a personal appearance? It is really...
Yeah, it doesn't have a right. He can only make a request.
Correct.
You can only make a request. Very interesting. Therefore, they say that the RESC will frame those circumstances under which you will be allowed to. Otherwise, no. Otherwise, the mandate is that the heading of Rule 11 of the faceless assessment scheme itself says no personal appearance in the centers or units. And interestingly, the board in the circular says you shall in any manner whatsoever have no role to play with the review unit. You can't go and meet them. You can't make a presentation to them. All you want to have could only be the other units concerned. And therefore, one of the units is set out from a personal interaction. Even video conferencing is not possible.
Right. Okay. Thank you, sir.
PVS, coming to you, this is like pockets of, I think the intention was to leverage on the expertise in the background, right? Whether it is transfer pricing experts or the functional experts or the valuation experts. But then the concept has been somewhat damaged, when the actual policy has been framed, but the entire assessment itself has now become faceless. Now, how do you see this, specific functional groups being, assigned, and versus the entire assessment being, done in a faceless manner? So, will this be beneficial in the long run? PVS, you have to unmute.
Structurally, the law has been well maintained. Now also we have got specialist functions, for example, transfer pricing, the valuation mechanism, and all those specialist functions. So a reference is made, you get a report or you get an order, and that's acted upon by the assessing authority. I think the technical unit will somewhat serve those purposes, but it could be a little broader than that. For example, a technical unit may even perform interpretational issue in case because the exact allocation of what a technical unit will do is not too sure. For example, if the board has a position of law and they which is not exactly stated in a circular, whether it will be referred to a technical unit and therefore a view would emanate from the technical unit, I'm not too sure. I think it looks possible the way it has been conceived. It is not a technical unit in the process of mere adjustments. It is a technical unit even for interpretation could be one view. Now coming to the review units. The review unit would happen. Strangely, the way I am reading the circular or the notification is that once a review unit has to be made, it doesn't go back to the same assessment unit. It goes to another assessment unit. So that means one review is taken, automatically it looks the confidence in the first assessment unit is not full or it is subdued, and therefore it is referred to another assessment unit to complete the assessment. So I do not know, the moment you are referred to a review unit, whether it results in taking away the responsibilities of assessments of assessment unit A or number 1 and it's thrown to assessment number 2, all are randomly selected is what the notification says. But the way a review unit is that it is a suspicion with the assessment unit 1 that it has not done the assessment as it should. It is checking the competency of the assessment unit is the way it looks rather than a mere review as would happen in a normal case. So I would think the review is a very serious mechanism within it's a control mechanism they have placed that if the assessment unit assessment is not properly done to the standards which the National E-Assessment Center would place, then they can put it to another review unit. Again, after the review is done, it does not go with the original assessment, it goes to another assessment unit. Strangely, we have to read the lines a little more closer. My reading is that it doesn't go back to the same assessment unit, it goes to another assessment unit, and therefore you may have a new kind of issues emanating from there. So I would think that the placement of this law or the faceless assessment is not exactly identical to our traditional understanding. The review unit powers are slightly vaster. It's actually who can review, as long as within the assessment, then nobody can review. Today's section board circular under 119 says nobody can give any instructions to the assessing authority. Now it looks like anybody can give an instruction to the assessing authority. So you find that quite a few instructions can flow from one authority to other. Now it looks as if 119 may even become redundant because the way it is structured, 119 itself would require some kind of a modification. Otherwise, some of this will look like influencing the assessments to an outcome which is desirable rather than an outcome which would come from the assessing authority.
Thank you, PVS. Padam, moving to you, there are multiple questions on the chat box as well, but all point to the confusion that people have in their mind as to who is really powerful in this assessment scheme. PVS also mentioned about the interference of the review unit. How will the views of review unit be taken? Whether it will be imposed, on the jurisdictional officer. One interesting question which has come is, when somebody passes an order and that becomes final, there is a 154 power which is left with the as part of the jurisdictional as part of the residual powers with the jurisdictional officer. Will this count as a mistake apparent on record if if there is a view to be taken differently by the assessing officer? Will he be empowered to change and rectify the order under 154? So the questions like that have also come on the chat box. Some interesting thoughts from you on this, Padam, would help.
This is bound to lead to, as what PBS was mentioning, we need to do a fine print reading of the various provisions between the functional division as to what happens between the regional assessment center and all of the centers concerned. And that, in my opinion, can give rise to a lot of difficulties, because as it is now, when we look into the way in which it has been designed, we find an overlapping of functions. Now, if you look into what the NEAC has to do, it says it has to make assessment. If you look into the scheme, Rule 4.1 of the scheme, what should the assessment unit should do under the regional assessment center? It says it shall make an assessment. Now today we have therefore the job of making an assessment both on the assessment unit with the regional assessment center, and the national assessment center also says I shall do the function of passing an assessment. There's no clarity today available. Now look at the verification unit. It says one of the functions that it shall do the job of examining books of accounts. That is coming under rule 414. Now there is also a technical unit which says I'll have the job of doing the forensic audit. That means I will examine the books of accounts. Now where do you draw a line? A natural examination and a forensic examination, whose view shall prevail, because both have been given the functions of examination of the books of accounts. As a result of it, therefore, there is a lack of clarity in my opinion. There's a lack of clarity. They have just done these functions concerned. How are you going to have some sort of a Chinese wall between them such that they have to be very specific? Because the board has reserved for itself the powers to make amendment to the scheme, to add any function to the respective units concerned. That's going to be again a situation where over a period of time, if you don't have a conceptual clarity in terms of how do you like to divide the functions, how do you therefore ensure that there is a proper coordination between these people, it's going to be extremely difficult, in my opinion, to have a hierarchy as to whose view is going to prevail. And this, in my opinion, therefore, this, in my opinion, is bound to give rise to a lot of litigation. In my opinion, a fresh type of litigation is bound to emerge, especially when a damage is going to happen to an SSC. He's going to look into all these minute aspects concerned. Who passed the order? What is the hierarchy? Is he competent to do that at all? What are the timeline? These are, in my opinion, bound to be a new type of litigation that are going to emerge solely as a result of a lack of hierarchy and a lack of functional clarity in terms of who shall do what and who owns the responsibility. In my opinion, very interestingly, there's a fundamental feature today. If National E-Assessment Center has to pass the order, interestingly, it does not hear the SSC at all. Somebody else hears the SSC. Assessment unit hears, or the verification unit will interact, or the technical unit will interact. The person who's supposed to pass the order, he never hears the SSC. Now, can you therefore have a situation where the person who's having the final authority to pass order passes that without having heard the SSC at all? This is some sort of a new concept that comes about. This is as a result of not looking through the fundamental essence of natural justice, not looking at the conceptual clarity, not looking at the roles. You're trying to say we'll join together dynamically. No. It doesn't happen that way. It doesn't happen like a corporate, we can join dynamically. These are all very functional issues. These are all jurisdictional issues. And when you go to a matter of jurisdiction, you've got to have extreme clarity in terms of who has jurisdiction and what manner he has jurisdiction. It's not like a corporate responsibility. Everybody can contribute. Somebody takes their responsibility up. That's not the way the income tax department is functioning. Therefore, you can't borrow corporate type culture here to say we will assimilate that in the income tax department. It's going to be extremely difficult.
Who will be the respondent in our appeals?
The respondent will be the National E-Assessment Center, because he is the person who is passing the order. But they're saying that it will be the jurisdictional commissioner shall be based on your assessing officer who was handling jurisdiction charge over you.
In fact, one of the questions on the chat box from one of the participants is, when the National E-Assessment Center passes an order, will they apply the jurisdictional high court and the tribunal bench decisions? Because it will be different. Today, Wipro and Infosys is in Bangalore, TCS is in Bombay. On the same issue, Bombay High Court has a different view, like the software TDS. Karnataka High Court has a different view. Will of course, TDS is different, but on a similar issue like that, will any AC apply the jurisdictional principles when they have to pass the order?
There was a meeting of the tax department, Bombay principal commissioners and others, with the Indian Merchant of Chambers and Commerce, Bombay, and there were questions asked by the INC, and the answers to that have been given by the chief commissioner, and they have been printed and circulated also. In that, they are very clear. The principal commissioner makes a very categorical statement that the National Assessment Center, when it passes the order, will honor the jurisdictional high court decision. Therefore, if you are at Bangalore and if you have a decision in your favor or against you, those will have to be taken into account while finalizing the assessment order. And to that extent, possibly there may be inconsistency, not driven by their own concept, but by the fact that the jurisdictional high courts have not concurred on a particular viewpoint. There are varying opinions of different high courts on this matter. This is the clarification given by the principal commissioner of Bombay, circulated in the conference with the IMC at Bombay.
Bala, I may pose one question to Padam just to continue that. How will Berger paints apply? I raised it at the initial level. Whether jurisdictional, I'm saying it should be even Berger paints beyond that.
See, yeah, he raised two interesting issues. He made a reference to Radhaswami Satsam, and he also made a reference to Berger paints. The question, therefore, is Berger paints is an interesting issue that if you have not disturbed somebody, you shall not disturb on that ground somebody else also. A company has not been disturbed to say, I'm accepting your proposition. That means in case of B company also, that shall not happen. Now, interestingly, the department has passed an order. Let us say inconsistently also. I will go in appeal. The department doesn't go in appeal. The question of inconsistency will come only when the department takes the matter from the CAT appeals further up to the tribunal level. At that point of time, they can say, Bala's case not taken, Sunil's case taken. That's an inconsistency. In my opinion, the aspect of inconsistency will come when at the second level of appeal that happens from the CAT appeals to the tribunal. The first issue, therefore, is about inconsistency in terms of Radhaswami Satsami's case. Now, this is a very interesting statement because the law is saying that the principle of res judicata does not apply to tax proceedings. We also have a contrary principle to say that principle of res judicata does not apply. Supreme Court is saying, no. If you have taken a particular stand, now that's interesting. Therefore, they say, if you have gone through the facts of a case and the facts of an assessee's case are consistent, there has not been a change, then you shall not be allowed to take a change of opinion. You can't have a change of opinion. And to that extent, therefore, we will ensure that there is consistency. And again, in my opinion, again is a proposition for the appellate authority. It's going to be extremely difficult to ensure that the AO accepts it, because ultimately, if the AO to accept that, he becomes the Supreme Court, his decision is final. He's always worried about it, to say that somebody were to take a wrong decision, he will lose the job of, or he will lose the ability to have that viewpoint upturned. So these are, in my opinion, both at the appellate levels, may be extremely difficult to box the assessing officer into that particular view of consistency, both across assessees and vis-a-vis the same assessee on the same set of facts.
Thank you, sir. Ashutosh sir, coming back to you, I did mention this in one of our earlier discussions on transition. So, what are the things that are happening as far as pending assessments are concerned? You know, how would that proceed? Any challenges that you see on submissions that taxpayers need to make, and also finally, what is your view on large taxpayers? Do you think, in your view, this is a beneficial thing of going to e-assessments? Because I think a lot of large taxpayers, do have a view that this may not be as effective as otherwise it's been till now.
So Sunil, let me answer your your last question first. Like I said, and like we've all been mentioning, this is a halfway house to functional in terms of functionality. What is the definition of functionality and specialization? You are saying that you have limited resources and you will then use those, and I'm talking from the department's point of view. So you will then use those limited resources in such a way that you get the best outcome. Now, let us say, for example, that that assessment of banks is a very specialized topic, not only from the accounting aspects of the bank itself. After all, it is for it. Its working capital is loans, right? So it's dealing, in giving loans and taking deposits. And similarly, in the Income Tax Act also there are very, very specific provisions with regard to banks. Similarly for insurance companies. Now, do you mean to say is that whether the assessment unit is faceless or not? Is it that that one assessment unit has the capacity sitting somewhere to assess one bank A, and another assessment unit has the capacity to assess bank B, and therefore you're utilizing your resources well? My personal opinion is that that is not how you carry forward or come to the final conclusion of having functional specialization. The whole idea about functional specialization is that you will have a unit which specializes in the assessment of let's say banks, and there that unit will be able to take a consistent view. It will have, all the legal propositions in place. It will have the accounting knowledge at the back end to see, what are the RBI regulations on, treatment of bad debts and all that. We've seen all those different case laws which have emanated in different areas. And that is where, you would get, as a large taxpayer, that is where you would or could get a benefit of a real functional specialization. I don't think we are there yet in this sense. Yes, the fact that, an assessment unit, in case, let's say, our bank has certain issues and, it can't decide, and therefore it will refer it to a technical unit. And the technical unit will then, come back to it. But again, I do not see, that structure at the back end in the department through their orders that, they have technical units who are specializing in particular, cases of particular sectors. So to that extent, I don't think that, taxpayers, large taxpayers especially, and I'm talking about large taxpayers because they are essentially, less than 1% of the total tax population, but are contributing, close to 90% of our taxes. But the point is that therefore, for them to really see the benefits, we need to come to that level of functional specialization. Even for transfer pricing, let me say that, currently, as far as we know, the interface is that at least for these assessments, the transfer pricing units will be in the same city where that taxpayer himself is located. Going forward, they may also transfer the transfer pricing unit to a technical kind of a unit. But again, then at least one has the comfort of knowing that within the department there is a specialized transfer pricing unit. Right, and to that extent, hopefully they will have officers who have a transfer pricing background when they do it. But I don't see that kind of specialization in in non-transfer pricing issues. That is the first thing. The other is we had mentioned again in all of this scheme this point about personal hearing. Now we all know that Article 265, which protects us as taxpayers of the Constitution, not only says that it has to be levied as per the law, but it has to be, collected. So by the authority of law. So as Padamji mentioned, the authority of law is very, very important even in the collection, and that is why on all issues of jurisdiction, the taxpayer has a right. And many times the departmental officers feel that we are nitpicking. Yes, they may be nitpicking, but the Constitution has given us that right up till the last moment, not only the levy, but the collection has to be as per law. Now, therefore, there has to be a clarity with regard to, how is my assessment taking place? Because right now, there was one assessing officer who was supposed to be, in charge of everything. Now we have split that into 4 units. And let me come back even to the review unit. The review unit, it seems to me, as there are 2 outcomes. If the review unit agrees with what the assessment unit has done, then it goes to the taxpayer and he has to give his response. If it doesn't, then it goes to another assessment unit, and then those complications arise, as Mr. Srinivasan mentioned. Similarly, in this hearing, for example, now it says that they will devise a scheme under which they will decide who has to get a personal hearing or not. Now, personal hearing can definitely be through a video interface. I don't think that is an issue. But does the principle of natural justice, can we stretch it to say that if some taxpayer is asking for a personal hearing, you can deny him that? So I think that is an important question which will get litigated in many cases, and I think they will fall back in many cases, I think, to a personal hearing, at least to a video conferencing, because I think they will also have a look at all those case laws with regard to what is natural justice. So these are, those things which are there. I also know that, of course, yesterday, you see, there was another set of jurisdiction orders which came about. But as of now, I know that there are a number of non-assessment functions which currently are stuck because the assessing officers, at least verbally, are telling taxpayers that they really don't have the jurisdiction, or they're not clear about whether they are supposed to do it or not, all those kind of things. And I definitely think that clarity has to come about quickly, because one is, of course, we have COVID upon us, and the interface anyway is difficult, at least, on all these non-assessment issues. And if we have this added, complexity, like I said, there are many department officers who are not happy with this change in circumstances. That doesn't necessarily mean that that's a bad thing. Only thing is that that cultural or that that induction hasn't taken place. Therefore, we definitely need much more clarity about the residual functions for taxpayers' benefit.
Thank you. Thank you so much.
Yeah, thank you, sir. I think we have overshot our time, so we'll come to the closing part of this panel discussion. Before we close, I'll take some closing remarks from each of our panel. I think we have debated this, but it is too early to decide on this. I think we have to give time to the government as well, because they are starting something which is new in the entire scheme of things. So therefore it is only fair that we give them some time for this to settle down. And with seeing the GST implementation, government was very responsive in terms of how they have addressed the implementation difficulties, and various issues were clarified from time to time. So one would expect that the same thing would happen here as well, and they will learn from the implementation and move forward. But I think what we started off with, the award objectives of transparency, accountability, while efficiency is fully addressed, but the transparency and accountability is going to see the light at the end of the tunnel, is what I think the panel has highlighted. Now over to Padam for your closing comments. Less than a minute, and then we'll move over to Mr. Dixit.
Yeah, 2 or 3 comments briefly. Talking about transparency and design issues. Look at the whole scheme. It was a situation where FM said, I would like to eliminate corruption. That's what she said on 5th of July, and therefore she said, I'm going to bring in a new scheme. Interestingly, the assessee does not know the assessing officer, but the assessing officer knows the assessee. It's an unfortunate portion of the story. To me, therefore, there's a design flaw. You have to rectify that. Like a CA examination, even the evaluation, the person who does the evaluation should not know who the officer is, who the candidate is. In my opinion, therefore, it's only the assessee does not know. The assessing officer knows who the assessee is. Therefore, the question is, would there be a real impact in terms of design being rectified? Going to be difficult, in my opinion. It's going to be extremely important, therefore, that the design flaw has to be addressed very carefully. In my opinion, also, we have to look at the taxpayer charter. Nobody's spoken about the taxpayer charter, and I thought I will therefore spend 2 or 3 minutes or 2 or 3 points of the taxpayer charter. Very interesting. But look at the flaws in the taxpayer charter, and I thought therefore associations like BCIC should take the lead on making some representations on the taxpayer charter. I'll make 2 or 3 points on this matter. The taxpayer charter gives you various rights concerned. It says, I will provide timely decisions on this matter. I will provide timely decisions. Now the question therefore is not timely actions. They don't talk about timely actions. I pass the order in an unfair manner. How I will take timely action to rectify that? Nothing is mentioned in the taxpayer's charter. They say I shall collect the correct amount of tax. Now, I don't want collection of tax. I want the levy of tax to be correct. When I levy the tax, it is to be correctly levied. You can't say I will collect the correct amount of tax. If the demand is raised against me an unjustified assessment 100 crores, you will collect 100 crores. You not collect 101 crores. I understand that. I'm not looking at the collection of taxes. I'm looking at the levy of taxes itself has to be correct. That's not happening. Interestingly, it says, I shall provide a mechanism for lodging complaints. Provide mechanism for lodging complaints. What's the fun of lodging complaints? You should provide the mechanism for redressing complaints. You're not looking at mention about redressing complaints at all. So you should make a reference to say that I shall have a mechanism for redressal of complaints. He's saying I'm going to hold the authorities accountable. Nothing is stated as to how you're going to hold the authorities accountable. Therefore, I thought closing comments are also as important, in my opinion, to go into the taxpayers charter and possibly look at modifying those to get some more accountability, some more benefit to the taxpayers concerned. I'll only at the last mention about the faceless assessment scheme. I was going through the dictionary meaning of faceless assessment scheme. What is the meaning of faceless by the dictionary meaning? And they get interesting viewpoint. It says faceless means nondescript. It says lacking a face. Lacking a face. This is nondescript. Now, interestingly, it says Cambridge Dictionary says faceless means having no clear characteristics and therefore not interesting. This is the definition of faceless under the Cambridge Dictionary. Now, one more definition was An insult indicating someone who refuses to see the truth. An insult to somebody who refuses to see the truth. This is the definition of faceless assessment. Now, is this the background which we have used the faceless assessment scheme? I thought there should have been a proper reference itself in the heading. You ought not to have used, my opinion, a faceless assessment scheme. That's a very unfortunate word being used. One unfortunate word being used, because the dictionary mean you ought to have begun job properly. Call it an electronic assessment. Call it somewhere else. Don't call it a faceless assessment. Huh?
Yeah, remote assessment.
You could have something like that. Don't call it a faceless assessment scheme. The word faceless doesn't convey the right meaning. And therefore, my opinion, the start itself is not fine. And possibly, therefore, I don't have great hopes to say that the culmination also is going to be very interesting. Thank you.
You know, I hope it remains with faceless and not become brainless.
That's why actually I was telling Shekhar made a mention. I said, look at a faceless assessment scheme. It means FAS. If you pronounce that, it says FAS. It doesn't have FARCE. FAS is very close to FARCE. FAS. That's the way you pronounce it. That's not the way it should come about. It should not become therefore a FAS. That's not the way it should happen. I hope that the powers that be are going to be having a little more conscious attempt to ensure that the implementation is done in the right spirit, not just for the sake of writing something. They have done it in the letter, but the spirit, nothing happens about it. That should not be the outcome of this scheme. Thank you.
Wonderful.
Padam, thank you so much, Padam. I just want to make only one point on BCIC. Me and Bala are working on the representation. Definitely, I would like to not just take your inputs. I would like to spearhead this along with Bala and Sunil and me before the CBDT and with other members on this faceless assessment, Padam. We need your help and support, Padam.
Fine, thank you. Fine, yeah.
Over to you, Mr. Dikshit, your closing comments.
Yes, I'll just take a minute to add that on the taxpayers charter, I had mentioned Article 265 of the Constitution, which always we always had a recourse to when it is said that that the collection is not as per the due authority of law. It's always great for the income tax statute to now also give me a statutory right under the taxpayers charter. And as Padamji mentioned, one or two insightful points about how it seems that charter is also has been just rolled out in order to meet a particular target of August 14th. But at least that charter is there, and I think we will definitely use his and others' good offices, if not before the CBDT, then before the judicial authorities. We do get a statutory right, and those judicial authorities can give those correct interpretations or better interpretations to that charter than what the language currently shows. That is on 119A section of the Income Tax Act, where we do get the statutory power. The other is, like I said, I want to reiterate, that the only thing about faceless which I see in the positive in all that definition it says is uninteresting. So if my assessment order assesses me at the same income at which I have reported, I'd be very happy with that kind of uninteresting outcome. But let me say beyond that actually has been rightly said, the most emphasis has been on this on this C word. But whereas you look at the statute and what the legislature intends, it intends, more efficient issue of resources, a better outcome for taxpayers because of specializations. So I would personally, this is my personal opinion, I would have wanted more a case where, you had assessment units which specialize. They could be sitting in metros or where, the officers had that kind of background, and particular taxpayers cases depending on their sector, and this was discussed by Bala and Sunil also, for example, software companies or, banks, that they get assessed by a group of, a group assessments where those persons have that knowledge, they have that kind of, accounting background also and all of that. That would, I think, would have been an ideal kind of an outcome. I don't think we've reached there. We are in a halfway house. Hopefully, the powers that we will realize that and we will get to that kind of, a situation as of now. But I would like to end by saying is that this is a paradigm shift in the way the department is going to interact with the taxpayer. The paradigm shift doesn't necessarily have to be a negative outcome, positive outcome, or neutral outcome. It's not preordained. Let us see how it goes. and let's see how it goes, especially the first set of faceless inverted commas assessments. What is that kind of an outcome? And then let's take the journey forward. Thank you, Val.
Thank you, sir. PVS, last word is yours.
Okay, okay. Number one, there are certain benefits we should be able to see. Number one, the waiting time at the assessing officer's doors, all those will reduce. So there's going to be better utilization of time. There's one, the assessment will be time bound because everything is now, you have to ask for time. If you're granted extra time, you can do. Third one, which will be the most important one, is that assessees will have a better assessment preparedness. I think since there is a scheme and you know it's going to be faceless, and I'm not derogatory in using the word faceless here, that it is going to be that you will get better prepared. How to write for an assessment, what are the exactness with which you will write. So the assessees will take better control over the facts than what it has been in the past. So I think that will be the third positive outcome, a positive one. The negative, I will say, I will pick up from the other speakers, which are quite daunting, to say the least, is that Padam said that faceless means that the assessee does not know the assessing officer, but the assessing authority knows the assessee. Take this as one signal. Ashutosh ji mentioned that the taxes shall be collected only with the authority of law. And therefore, that's the second requirement, that it should be collected only with the authority of law. The third one is that there is no accountability which is seen apparently in the system. We see there's a institutional accountability, though no personal accountability. So if you collect all the three dots, it could be sending a very unusual signal for you that you are not going to be comfortable with this assessment unless it is very well handled by at an institutional level.
Final comment to you, Bala. And probably we should have an interactive session with the Principal Chief Commissioner of Income Tax in Bangalore. And then probably need to give our views and need to take his perspective. And then probably we should also plan interact at Delhi level, but let's plan it at first at local Principal Chief Commissioner of Income.
Yeah, absolutely. Shekhar, I was about to say that what we would do is probably seek inputs from the members. We would, as you rightly pointed out, we would seek help from Padam sir as well. Use his expertise and make a representation, and then we will have some interactive session with the officers. But we will also have a little more information. Once the September 25th notification on the faceless appeals is also rolled out, because in my opinion the appeals may work out much better than the assessment, but we will see how it pans out. It's been a wonderful discussion here. We broached all the topics.
Only one request, Bala, Sham, please write an official letter to Principal CCIT by tomorrow itself, signed by me, asking for a date for
Yes,
a
sir.
webinar so that it gets closed out immediately.
Sure, we'll do
Sorry,
that. Yes, sir.
go ahead, Bala.
Thank you so much for the panelists to come here. We have overshot the time by about 30 minutes. It was a very interesting discussion. Both positives and negatives came out. I think we have to live with the system because this is here to stay. So therefore we will look forward to the positives and see how we should mitigate the negatives using the good officers of the chamber and the experts who are here. Thank you so much, and thanks to all the participants for having spent their good part of their Saturday with us. Thanks to the
Thank
office
you.
bearers of BCIC for arranging this webinar. Thank you so much.
Thanks a lot,
Bala.
everybody.
Thank you.
Thank you.
Thank you, everybody. Bye.
Thank you.
Bala. Thank you.
Bye bye. Bye bye.
Bye.